his day, was truly one of the great labor lawyers and trial lawyers in this city as well as the United States. And when I first became dean, Buddy was always sitting right up front with the Segal lecture, always evaluating the quality of the Segal lecture. And then there would be a moment in the lecture when Buddy would come up with this big, broad smile, knowing that the lecture met his standards. And certainly, over the years, we've had some amazing Segal lecturers, Walter Dellinger, Ted Olson, Floyd Abrams, David Boyes, the list goes on and on. Each of them, I should mention, of this particular group were known not only obviously as great litigators, but also great Supreme Court advocates. I mention that today for two reasons. First of all, as I think many of you who've been reading the newspaper know, we have a number of very interesting cases that are before the Supreme Court at this moment in time, enormous implications. But secondly, today's Segal lecture, the 2012 Segal lecture, is as knowledgeable, thoughtful, and respected as an advocate before the Supreme Court as you'll find. Now, as to the first point, obviously, among the cases that are before the court at this moment is the constitutionality of healthcare law. This obviously would be an important test of the limits of the Commerce Clause. But also, it deals with fundamental issues involving our healthcare system, our political system, and obviously raises significant first issues of legal oppression. Also coming up in the near future, next year, will be the closely watched University of Texas affirmative action case with significant implications, not only for higher education, but our views of diversity and affirmative action. I mentioned all of this, sort of these two very important cases, because we couldn't have somebody better positioned to comment on this and other issues, as well as the way in which you develop a Supreme Court practice. This year's Segal lecturer, Tom Goldstein, I think is truly one of the kind. He runs perhaps the only firm literally limited to the Supreme Court litigation, leading one observer to describe his, and I'm quoting, his chutzpah, comparing his developing enterprise to somebody who started a catering company that only served royalty. His practice has clearly shaken up the old order and helped establish the new line of business of Supreme Court specialization. 30 years ago, when I was in Washington, another lifetime ago, Supreme Court practice was truly not specialized at all. Indeed, as Tom and I were talking about before, when a case made it to the Supreme Court, the senior partner or the attorney general would take it over from the person who litigated it before, and they would litigate before the Supreme Court, leading to the observation at the time that some of the worst advocacy occurred in the Supreme Court. It is not that way today. Tom was explaining 75% of the cases now before the Supreme Court are litigated by specialists. And he clearly is somebody who has helped spearhead this change. He's argued nearly 30 cases, maybe more, who's keeping count, with his firm Goldstein and Russell, and has served as counsel or co-counsel in 1 out of 10 Supreme Court cases. That is a remarkable statistic. His omnipresence stems from his ability, not only as an advocate, but to figure out ahead of time what cases will be or are likely to be taken by the court. Obviously, we'll identify some of the decisions ahead of time. He is also, I should know, known for his publication of the SCOTUS blog, which is required reading for lawyers, law professors, journalists, and as rumor has it, even justices. It gets over 15,000 hits a day. I don't know if it's possible to figure out how many are coming from the Supreme Court, and is the only weblog to ever receive the American Bar Association's Silver Gavel Award for increasing public understanding of law and the legal system. son of a lawyer. He started his singular journey with a Supreme Court expert after his first year as a law student at American University, where he served as a legal intern for Nina Totenberg. This was in the early 1990s, the venerable PBS Supreme Court correspondent. Before the decade was out, he argued his first Supreme Court case at age 29. Imagine arguing your first case before the justice of the Supreme Court. He survived that experience. I can assure you I would not have. It was during this formative stage that he crossed paths with two legal legends, David Boies, the famed litigator who passed the lecture, as well as Lawrence Tribe, Harvard's elder constitutional statesman. Both Tribe and Boies selected him to serve as their top lieutenant. Bush v. Gore, working alongside them, cultured his interest in the Supreme Court and convinced him that he could, in a sense, be a leader in this field. And with that, he has served as head of Supreme Court litigation in a variety of firms in D.C., as well as the co-founder of his own firm, Goldstein and Russell, which he's going to talk about, which has worked on a plethora of cases and filed more than 150 briefs. Among the cases he's been involved in have been Georgia versus Randolph, which is tested the balance of Search and Caesar, as well as Hamilton v. Rumsfeld, which challenged the constitutionality of creating special military tribunals to try enemy combatants. Thomas Furr, who's co-counsel in Hamden, won both cases. In truth, he's been successful petitioning the court, so successful with the backlog that he has developed two premier law school Supreme Court clinics, both at Harvard and Stanford, two premier clinics, and we were talking about Penn's premier Supreme Court clinic. Really, these are the leaders in that field. His innovative partnerships with these clinics, his bold solicitation of Supreme Court cases, and his blog stimulating take on the court truly make him one of the most interesting legal figures in Washington. He's been called, and I quote, one of the 50 most powerful people in Washington. He's been called the Prince of the Court and also a walking soundbite machine. We call him truly original, and I can assure you that Buddy Segal would be brimming with pride about this year's Segal lecture. So it is my distinct pleasure to welcome you to the 2012 Segal lecture on Goldstein.
Thank you, Dean. Thank you to all of you for coming. It is really the single greatest honor of my career to have the opportunity to come and deliver this lecture, to deliver a lecture that is in the name of a legal giant, Buddy Segal, someone who loved this law school and loved this institution and really stands for, in his life's history, really everything that is great and right about the law. This is the 10th anniversary of his passing, and he was completely committed to the practice of law, and including in making this lecture possible. I am going to talk about the Supreme Court, and I'm going to make sure that we have time for questions so that we can talk about what interests you about the Supreme Court. As the Dean said, there are all kinds of incredibly interesting cases coming before the court. He mentioned, of course, healthcare and the affirmative action case. There's going to be campaign finances back. Section 5 of the Voting Rights Act is going to be back in front of the Supreme Court. Proposition 8 and DOMA, gay marriage before the Supreme Court. Fascinating, fascinating things about the place where I have the great opportunity to practice. I'm not going to talk about any of them. I am instead going to talk about entrepreneurship in the law, if you don't mind, if you will give me that opportunity. What I want to talk about with you is what I think about the practice of law, the barriers that exist, and the opportunities that are created by the way the law has so much inertia behind it and is so resistant to change through the lens of my own experience. You know, I think that I could come and lecture to you about constitutional law or, you know, administrative law, something that's going on at the Supreme Court. But what I can tell you best is what I've experienced. what it is that has driven me to do the things that I've had. Not because they're great, not because I'm a tremendous lawyer. There are a lot of lawyers who are better than me. Not because I have the best sense of the practice of law, but it is what I know. If you do something for 20 years, and you know, which is almost how long I've been practicing, if you think a lot about what you want to be as a lawyer, that is what, if you're going to convey to an audience as thoughtful as you all who are taking the time to come, that's what I can tell you best. I'm going to tell you about my practice, why it is that I did the things that I did, and why they were different. And then we can talk about that in the questions, or we can talk about the Supreme Court. And to talk about those things, I want to start with you on February 22nd, 1994. And February 22nd, 1994 is a date in which a case called Digital Equipment versus Desktop Direct was argued in the Supreme Court. And it was argued by two very famous lawyers. There were lawyers who were already very famous, and one of whom would become even more famous. One of them was Rex Lee. Rex Lee had been the Solicitor General of the United States in the Reagan administration. He had had an incredible career. He had graduated first in his class at the University of Chicago Law School. He had gone straight to clerk for Byron White. Within 9 years, he was the dean of the BYU Law School. He was a giant in the law. He was arguing for the respondents that day. On the other side, the other table, was a guy named John Roberts. John Roberts had done all right himself. John Roberts, after having grown up in Indiana, had gone to Harvard College, where he graduated summa cum laude. He had then gone on to Harvard Law School, where he had graduated magna. They only do summa every 5 years. He can be forgiven. It worked out. He worked then for Henry Friendly, and then clerked for William Rehnquist. He had gone into the Department of Justice. He had later become the principal deputy solicitor general. And in 1992, a couple of years before he had left the Justice Department and the Solicitor General's office to head up the Supreme Court practice at Hogan, now Hogan Lovells, where he had been a partner before. He had been out in private practice. And Rex Lee, in 1985, after leaving being the Solicitor General, had gone and started the Supreme Court practice at Sidley and Austin. So those are two figures in our drama, John Roberts and Rex Lee, and they stood for and stand for all that is the best in the law. Those gentlemen were giants, had the greatest integrity, the greatest skill, the greatest reputation. They are what we could all aspire to be. The third person in our drama is me. I had a slightly different profile. In 1994, I had just gotten back my first legal research and writing assignment. I had gotten an F. I love American University's Washington College of Law, nonetheless for the fact that when I applied to law school in 1992, every single law school that I applied to rejected me. I had not had the most distinguished career at the University of North Carolina at Chapel Hill, a place I love greatly, except perhaps in drinking, where I was really well renowned, actually. I had, as a second-year law student, applied to Washington's finest law firms, including both Sidley and Austin, where Rex Lee was at, Hogan, Hartson, where John Roberts was at. They had thought it would be better if I pursued other opportunities. So we were in a different space, as it is said. And I want to just describe for you kind of the different place that you can find yourself in and what messages are being told to you as a lawyer, as a would-be lawyer, and the like. Because at that point, the message that was given to me, not intentionally, nobody was like talking down to me, but the sense, the felt sense was that there is a place in the law that is very highly regarded, and we have a handful of extraordinarily talented, elite lawyers. These are the people who can do this. You will now go do something else. And in the law, we have a kind of sense of what it is to be a lawyer. There are big firm lawyers. There are some people who will go work for public interest organizations. There will be people who will be, and this is obviously the highest calling in an institution like this, they'll be law professors. I mean, if you really are going to live the dream, you'll be a law professor. But there are a handful of things that a lawyer is going to do, and there are just specified models. And there are people who can do certain things and people who won't do other things. And that is the situation that I found myself in February 22nd, 1994. And that is the people who do Supreme Court litigation are these incredible superstars who went to the nation's leading institutions like this one, went on and clerked at the Supreme Court and worked in the Solicitor General's office and had done dozens of cases at the court and were hired by the nation's largest corporations at the biggest institutions, the most highly regarded law firms, to do the very most important cases. Now, the thing about that is that as an economic matter, it makes really no sense at all. That it should be such a limited club, that it should be an oligopoly. Because think about Supreme Court litigation for just a minute objectively. The barriers to entry to this marketplace, to be a supplier of Supreme Court litigation, are extremely low. Here is what is required. You must practice law for 3 years, not have been disbarred, and you must have $200. That is what's required to become a member of the Supreme Court Bar and be authorized to practice in that court. That is, the American Bar Association will tell you, a set of qualifications that is met by almost exactly 1 million people in the United States, practicing lawyers who've been in practice, haven't been disbarred, and have 3 years experience. The nature of the practice is one that has extremely low overhead costs. It's not expensive to do. The briefs that I write and the work that I do can occupy a folder. I don't do depositions. I can't spell deposition. I don't go and try cases. I don't have to deal with witnesses. I don't do extremely complicated analyses of legislation that might be passed. All the things that are hard that lawyers do that require massive amounts of efforts, infrastructure, secretaries and assistants and associates, I don't have to do them at all. I don't need any of that to be a Supreme Court litigator. Ethically, the barriers to entry aren't even very significant either. It's true, and thank goodness it's true, that lawyers don't pick up the phone and call some other lawyer's client. But if you want to get involved in a Supreme Court case, what you can do is you can pick up the phone and call someone who has a Supreme Court case. There's nothing ethically wrong. That is another lawyer. Nothing wrong at all with trying to get involved in that way. And one other kind of not very well-known piece at the time is that identifying Supreme Court cases is not hard. Now, the general sense is that the Supreme Court grants 1 out of every 100 cert petitions that is filed before it. That is true, but like most statistics, is a lie. In the real world, it's not actually true, because the overwhelming majority of cases that the Supreme Court agrees to hear fit a very simple profile of cases that involve conflicts between 1 or more courts of appeals. It's not, you can't just throw a case up there and hope for the best and like, I got a 1 in 100 shot and I got as good a shot as everybody else. But that was the sense, that you couldn't really decide, I'm going to find a case that's going to go to the Supreme Court and I'm going to take it to the Supreme Court. The last thing that's true about there not being very many barriers to entry in 1994, when there were only a handful of people doing this, is that there were only a handful of people doing this. There are 1 million lawyers plus in the United States of America. There were 5 people trying to do this. In 1986, when it was that Rexley came out of the Solicitor General's office, the court was hearing 156 cases. Now, by 1995 or so, the court had kind of hung out the going out of business sign and had, shrunk that down to 78 cases. But it still was deciding, that's 78 cases. There are going to be 2 lawyers in every case. There are going to be the occasional amicus argument. There were about 150 slots up there. But nobody was trying to actually get involved. And that is one of the fascinating things about the law. And that is, if you go to law school, you are told kind of this is what you'll be. And nobody tells you that actually what you can do is you can go out and build a business. What you can do is you can find a niche, someplace where there are low barriers to entry, someplace where you might really enjoy to practice law, and you can just decide to do it. And so my story is a story of deciding that, gosh, that would be really, really interesting. Rather than being associated at a big corporate law firm, I would rather argue Supreme Court cases. And my story is, which wasn't a great insight, right? Do you think I was the first person that occurred to? And trying to figure out how it is that I was going to do that. And my story is that when I, in February 22nd, 1994, decided that I was going to go down this path, basically, what I decided is Rexley, who had been the Solicitor General of the United States, John Roberts, who had been the principal deputy Solicitor General of the United States, they had clerked at the Supreme Court. I knew I was never going to have their profile. And so what I decided that I needed to do was take everything they had done and do the opposite. And that's what I did. And that's what I really want to talk to you about, is how it is that you can look out and have people that you admire so much, that you wish you could be. If I could be John Roberts right now, it'd be a good gig, right? You would want, if you are ever offered the Chief Justiceship of the United States, you should immediately accept. And I would. Rex Lee, it's different, he's dead. But if I could just, maybe even for having his reputation, I would take it. But I was not those gentlemen. I admired them greatly, and I do to this day, and I will to my grave. But I was not going to be them. And so if I was going to be able to do what it is they do, I was going to have to zig where they zagged. And so here are the things that, in my experience, I did. And I offer them not because I think, this is kind of I'm not going to lecture to you about digital equipment versus desktop to app. I'm not going to lecture to you about how it is that you win a Supreme Court case or get cert granted, because that's not really a translatable lesson. You're not about to go, the Penn Clinic here is unbelievable, offers an incredible experience. But in the main, you are not Supreme Court litigators. And if you were to tell me something, I would hope you would tell me something that I could then apply. And so I'm going to describe this in a way that it doesn't say you should go do this. I don't need any more competition. I hope you don't do this. But what I do encourage you to do is think about the ways in which this is translatable into your own lives, the way I would take lessons from you. So these folks had gone to big institutions, Hogan Lovells, Sidley and Austin, incredible law firms. I started my own law firm, right? I was not going to get hired by some big law firm to be the leader of their Supreme Court practice. When I came out of law school in 1995, I clerked for a year, but after 2 years, I had not argued in any court, and I decided that I was going to argue in the Supreme Court. I was at Jones Day, a fantastic law firm, and the head of my practice, Tim Dyke, I told him I had gotten involved in some cases. I said, I have this case that I'm working on. I would really like to argue it. And he said, we're not trying to discourage you. We just think it would be great if you would, argue in a court of appeals first. We're not trying to slow you down. We just think maybe, we know you've taken the tour of the building. You're very familiar with the facilities, right? We think you have a very good, solid footing in the topography of the Supreme Court. We're looking for a little bit more. And really, our malpractice insurers are really encouraging us to look for a little bit more in lawyers before we put them before the Supreme Court. And I left. I quit in that meeting. I said, I'm going to go off and do my own thing. The lawyers who were before the Supreme Court they had gone to big law firms, and their preference was to not engage the press. There was a tradition, a felt sense that it was improper to be out there talking about cases, talking about the Supreme Court, because maybe the justices would not like it. And that's also a very long-standing, very important, perhaps, tradition in the bar generally. So I did the opposite. And it was actually extremely important to my career. What I had done is when I was, as the dean mentioned, Nina Totenberg's intern, I had done these statistics about the Supreme Court. And by statistics in the law, I mean what most lawyers mean, and that is I had a calculator. And the calculator, I would add up the number of times that two justices voted together, and I would divide by the number of cases, and I would come up with, Justice Scalia and Justice Thomas voted together 110% of the time, something like that. And that was a kind of lawyer's statistic. And I would put all of these numbers together, and I had done that as a second-year law student. And then when I graduated, I continued to publish these statistics. And the wonderful thing about ethics is that journalists have them too, and journalists who apparently did not have a calculator of their own wanted to use the statistics that I was preparing about the Supreme Court. These statistics, by the way, are utterly meaningless. They tell you nothing valuable whatsoever. If I tell you that two justices vote together 87% of the time, it doesn't tell you anything about the nature of the cases. It doesn't tell you anything about why they do those sorts of things, what their jurisprudence is. But it takes something that's very complicated and makes it simple. It is perfect for the national media. It just gross overgeneralization, that's us. And so when I was a first-year lawyer at Jones Day, the New York Times and the Wall Street Journal and the Washington Post and the USA Today and yada yada, they took these statistics and they made pretty charts out of them and they published them. And they faced a dilemma of their own, and this was the journalistic ethics problem, and that is they could not say, according to some guy named Tom, the justices X and Y vote together 87% of the time. Instead, they had to, and this was the fudging bit for them, justify why it is they were relying on me for these numbers, and they said things like, according to Tom Goldstein, who is an expert on the Supreme Court's docket who studies the court very carefully. That was not true. I did not ask for a correction. But nonetheless, it was, in my first year in practice, I found a niche. And I found a niche by engaging the press. And there are a million niches out there. This is not something that's unique or special, but it was one thing, oddly, lots of newspaper stories being written about the Supreme Court. They wanted these easily quantifiable number, this easy quantification of what was going on at the court. I was able to provide it. They had to justify relying on me. But this became very important because the third thing that Rexley and John Roberts were not doing was out there hustling. They weren't out there hustling really for two reasons. The first is they didn't need to go out and hustle. They were Rexley and John Roberts. People came to them. They came to them with incredibly important cases, incredibly big cases. Nobody was calling me. I was in a different situation. They were not going, okay, we got John Roberts, we got Rexley, but we also got that guy in his house who hasn't argued any cases yet, but he just looks like a hustler. That's the guy I want. Yeah, let's set low expectations for the justices. Some, very unusual litigating strategy. But what had happened is that because I had done the things with the press about the Supreme Court, and because I was willing to hustle and try and get involved in the cases, and because the Supreme Court is so formulaic, but yet nobody was going after the cases because of this sense that it was kind of improper, I would call people who had cases these are just the lawyers, not the litigants, call lawyers and who had cases that involved circuit conflicts, and I would try and ingratiate myself and become involved. And this was a difficult conversation because basically what I was saying to the person was, you have a Supreme Court case, don't you want to give it to me? The answer, if you ask that question, will always be no. And so you can't answer that question, but I talk to people about becoming involved, and they would not be idiots. They would eventually, by the way, I think you may be standing in front of a webcam. Hi. That was the back of the photographer's head. So they would, it's nice. It was fine. I would call these people and I would say to them, I'd like to become involved, and they, not being idiots, would say to me, okay, what experience do you have? Now, there were two ways of answering that question. The first is I have never argued a case in any court in the world. I have not been a Supreme Court clerk. I didn't work in the Solicitor General's office. That is not a persuasive answer. But what I was able to say is, the New York Times and the Wall Street Journal have just described me as an expert in the Supreme Court's docket who watches the court very carefully. In effect, I got a reputation and then backed my way into it. The way you're supposed to do things is that you are supposed to do something well, learn what you're doing, and then be recognized for it. This is extremely inefficient. It is right. If you required me in 1995, having just graduated from the Washington College of Law, to argue 20 Supreme Court cases before I could be recognized as a Supreme Court litigator, it would be impossible. So it was much better if I could become recognized as a Supreme Court litigator and then go litigate the cases. And it would all work out. Within 15 years, I would catch up with the experience that I essentially claimed at the beginning. And that's how I got my first cases. So Desktop Direct was a case about interlocutory appealability. It was argued in 1994 between two giants of the law. The next case on the same question as Desktop Direct, on the question of interlocutory appealability, was a case called Cunningham versus Hamilton County in 1998, and I argued it because I went to Teresa Cunningham 2 weeks before her cert petition was due. Teresa Cunningham was actually the litigant and the lawyer. She was representing herself pro se. She had been sanctioned as a lawyer. It was true of a lot of my early clients. And she had not gotten around yet to writing her cert petition in the case. And I said, look, I'll just do this for free. And basically, my marketing approach in the early cases that I did in the Supreme Court is, what have you got to lose? I mean, you've lost. How bad can it be? I did not print business cards saying that. I didn't go out, I didn't, it wasn't something that I really thought of as this is going to be it, this is Coke, what a great drink or whatever, and mine's going to be, it could be worse. But I went to people and I said, I will work on your case. And whereas John Roberts and Rexley were being paid in the hundreds of thousands of dollars to do cases, The market opportunity that was presented to me was there are a bunch of people who don't have any money, right? Whereas John Roberts and Rex Lee had responsibilities to their big corporate law firms for which they were incredibly important to the economics of the place to generate millions of dollars in revenue, I was in my third bedroom, and my wife was working at Steptoe & Johnson and pulling down a fine salary. And so for the first 8 cases I argued in the Supreme Court, I was paid $8,000 in total. And so what I decided was that there were a bunch of cases out there in the Supreme Court that no one, for some reason, was going around and picking up, and that there wasn't any justification for that at all. And then I took some of these ideas and these opportunities and kind of put them on steroids. The first one was the blog, SCOTUS blog. And here, again, was something that kind of I thought would be a good idea and ended up being a good idea for a completely different reason. So the idea behind SCOTUS blog was, look, we are doing a whole bunch of Supreme Court cases. We want to be known. My wife had joined me by then. We had moved to the second bedroom of the house. We were really expanding. The idea was we want to be known as Supreme Court litigators, so let's do this blogging thing. It was very new. This was 10 years ago. And people who go onto the Google thing on the internets, which is, is how we thought about these things a mere 10 years ago, will see us and will decide, these are the people we should hire. It turns out to be completely untrue. If you ask the general counsel of General Motors who it is that they're going to hire, so they go down the list. Okay, John Roberts. All right, that's an option. Carter Phillips, Maureen Mahoney, Kathleen Sullivan. They're the people with the website. Them. Just like, the person who hustles after the cases or just has the website, that's not going to get the job done either, particularly in the early days. But it is extraordinary, the fact that there's a great public interest in the Supreme Court. The number of people who really care a lot about the healthcare litigation is obviously extraordinary. Gay marriage, whatever. The court is one of the central institutions in our government, and there is just a fantastic hunger for information. At the same time that the mainstream media is obviously going through enormous economic turmoil, having to cut back, not able to devote the resources to reporting that it otherwise would. And we put out there this blog thing. And it cost me, by years 4, 5, 6, and 7, it was costing me $250,000 a year. And that's another thing that you just come to realize, and that is you're going to have to invest in yourself, in your own practice. If you're going to go out there and you're going to do a bunch of pro bono cases to find opportunities for yourself, if you're going to try and build an institution, this law school is an incredible institution, Schneider-Harrison, where Buddy and his brother practiced, and kind of build that institution. If you're going to do that, you're going to have to invest. You may have to spend a lot of money, and I did that through the blog. And the blog now will, there'll be 10 million visits to the blog this year. And the blog is by far what I'm best known for. And there's nothing magical about the blog, where if you're interested in patent law, I'll blog about patent law. If you're interested in immigration law, what have you. It is, you just create the thing on the website, and if you know something about it, people will find you. And over time, if you stick with it, whether it's your law practice or what it is that you're writing on the internet or whatever, people will be duly impressed. If it's what you love, if it's what really interests you, then you will do it well. I am not, John Roberts and Rex Lee are smarter than me. I'm not smarter than the people in this room. What I did is I picked the thing that I love. And I spent a lot of time on it and stayed very focused on it. The last thing, when I mentioned doing things on steroids that was a little bit different, was this notion of the clinics. So in 1994, John Roberts argued that case, as I mentioned. His second chair was a guy named David Leach. David Leach is now the general counsel of Ford Motor Company, a brilliant and wonderful guy. David Leach had just come, like John Roberts, from clerking for William Rehnquist. Rex Lee's second chair in the case was a guy named Carter Phillips, who's the managing partner of Sidley & Austin, D.C. They had started that Supreme Court practice together in 1985. Carter Phillips just finished arguing his 75th Supreme Court case. These people, John Roberts and Rex Lee, were themselves working with super-duper stars. And the lesson that I derive from being able to get involved in these Supreme Court cases is that you don't have to be at the pinnacle of the bar. And so what I said is, I've got all this pro bono work. My wife was thinking that it would be awesome if I brought in $10,000 in income over the next 3 years, something to contribute to the ongoing effort. And so I thought, what am I going to do? Who will help me work on all of this pro bono litigation? Well, I know who would do a lot of work for free. Law students. Law students they got nothing but time. And they would love to be involved in a Supreme Court case. Now, clinical legal education in the United States through the mid-1990s had gone through kind of a renaissance. It was really expanding. There was a lot of interest in it. But there was a felt sense in the law schools that you couldn't do this either. Remember, John Roberts and Rex Lee were arguing all of the Supreme Court cases if there were specialists involved. Since only 1 out of every 100 cases was going to be heard by the Supreme Court, could you give the students a good experience? Were you just going to have them writing amicus briefs that nobody would pay attention to? Or could you actually get involved in tons of cases, as the Penn Clinic is now? And my experience as a Supreme Court litigator, in the very first year of my law firm, we did have 1 out of every 10 Supreme Court cases. And we have had 1 out of between 8 and 12 Supreme Court cases for the following 14 years. Because you can identify the cases and go out and get them. And so we went to Stanford and said to Stanford, look, I think we can do this. And they created the clinic, and then Harvard, because Harvard competes with Stanford and with Penn and with Columbia and with Yale for students, said, we got to have one of these things. And Elena Kagan invited us to do one in the winter term at Harvard, and so we started the clinic there. And so we now got a huge amount of free labor from incredibly talented students who are unbelievably motivated. And a lot of these things that we've done are now, it would be much harder to do them. And that's one of the things that you have to realize in whatever opportunities you're going to pursue, is that no matter how much inertia there is in a profession, and there's a huge amount, as I've said, in the law, people won't just sit idly by. And so there are downsides to being at the tip of the spear, and there are upsides. You do have a first mover advantage. We got out there, I got involved in cases in a way that I wouldn't have had the opportunity to if I had graduated from law school, in 2010. On the other hand, you are going to ruffle some feathers, and you've got to recognize the dilemmas that are created. So I'll give you 2 illustrations, because sincerely, the point of this lecture is not like, oh, look how great this was. Because it's not like it has always been the easiest thing to do, or that I've done it particularly well. So there was, in 1997, a lawyer who was a member of the established Supreme Court bar who, when asked in an article for the American Lawyer, what do you think about this idea that people are going after cases, said, well, imagine that you needed heart surgery. And would you really want to pick the heart surgeon who calls you and says, look, I'm a heart surgeon. I can do this for you. Is that who it is that you would hire? Now, that lawyer was, and that was sort of the reaction, asked about my practice and how it was I was building my practice. That lawyer was John Roberts. And so, I think he was kidding. I think it was just a hoot. But the established, members of the bar, the institutions are not going to react well. Another example is that in a front page profile in the USA Today of, I think, John Roberts and Carter Phillips and me, Supreme Court Justice, unnamed, said that the justice thought I was an ambulance chaser. And so you have to be really ready to have people not approve of what you're doing. And I don't say that in a judgmental way. There are great things about inertia. The practice of law really slows you down. It is a brake on a lot of innovation, but it is a brake on a lot of things going bad. And you have to be prepared for people to say things about you that aren't very nice. And you have to, I would do a lot of things differently on reflection. I wouldn't be out in the press as much. I wouldn't be kind of jumping around asking for attention in a way that I think annoyed some people. You have to be able to look back and say, I've made mistakes in how it is that I've done this. But if you're going to do something completely different, you just have to decide that you absolutely love it and are willing to just give it your all. And recognize that each one of us has some area of the law, some area of our personal lives that we really can excel at, and we're going to wake up every morning, and because we love what it is that we're doing, we're going to do a really good job. I do wish the law would change some. I do wish that there wasn't so much resistance to change. It is resistance that is going to cause the collapse of a third of America's major law firms. Law firms are terribly run businesses because we're here at the University of Penn Law School. We are not at the Wharton School. And the people who decided to go to the law school decided not to go to the business school. It wasn't for lack of intelligence. It was for a different disposition. We're bad managers. We're not good at business. We're not intuitive about those sorts of things. We're not good entrepreneurs. And those are all things that are required for change. And in an era in which law practice is much more international, where we're competing against law firms from around the world, in an era in which the economy is changing a huge amount because of the internet and all kinds of other technological changes, we as lawyers have to be able to adapt faster. On the other hand, entrepreneurship is generally fast and loose. Generally is an overstatement. But it really does involve going out and just, I'm going to try and create this thing, and there's going to be some collateral damage, but on the whole, it'll be good. You know, in the dot-com era, lots of companies were built up and destroyed. We have clients. We can't afford to just kind of go out there on a wing and prayer and try and do the best we can, and if it doesn't work out, you know, on the whole, things worked. And so there are dilemmas about entrepreneurship in the law that don't exist in other professions. It exists, or in other parts of the kind of, in the economy. It does exist for doctors, for example. You know, you can't just say, hey, you know, maybe this form of surgery will work. Sorry about that. You know, that's going to, you know, we have a responsibility each to our clients, to our patients and the like, in the way that Google doesn't. And at least in medicine, though, there's innovation in technology, medical technology, whereas in the law, there's almost no innovation at all. And I do wish that institutionally we were more inclined towards change and towards shaking things up and towards creating more opportunities for people. So that's my experience and how it is that I kind of became a Supreme Court litigator, what it is that drove me and some of the mistakes that I'm willing to admit on camera. And we can talk about those things in the time that we have available for questions, or we can talk about the court, because I do love that institution and that place, and questions of doctrine and what's going on with the court and who's going to win the healthcare cases and things like that. But I'm very grateful for your time and attention, and for having me.
To give the law and entrepreneurship lecture next semester. I want to open this up for questions both about entrepreneurship and what leads us to be so conservative in the law, and then maybe we'll hear who's going to win the healthcare.
Tom, you mentioned the increasingly international nature of practice of law. I wonder whether you think that breaking down of some of the traditional barriers to innovation in the UK and in Australia are likely to lead to the breakdown of such barriers. Here, for instance, the prohibition against ownership of firms by non-lawyers. And then you think if you put some investment capital in some law firms, you'd get some innovation.
Yeah, if you had if you had a sense of ownership. Yeah. I don't think so. I think that, right. It's my experience that the people like the organizations like the American Bar Association, God bless them, have a sense of propriety and how things ought to be that is also coincident with their desire to maintain a monopoly. And you know, people who are in senior positions really do tend to believe that the way they have done things is the way that it ought to be. That, for example, if you allow businesses to hold an ownership interest in big law firms, which are billion-dollar corporations, after all, literally billion-dollar annual revenue corporations. I was the head of litigation for Aiken Gump. I had 250 lawyers in my department, $200 million in revenue in that one department. That if you allow this to be about profitability, that will change your standards, you'll be less responsive to clients and the like. The reality is that ship has sailed. That is particularly true both in the demand for higher profitability in American law firms and also the fact that we are now in a purely free agent market. Any law firm institution has 10 people who could go down the elevator in any one day and destroy the firm without question, and who are all thinking about doing it. The senior partnership, who are the folks, and it doesn't even have to be senior, but the principal folks who kind of drive the revenue. So if you were to think about Schneider Harrison back in the day, Buddy was a great trial lawyer. Bernie, his older brother, who went to this law school as well, they both graduated first in their class. Bernie was the rainmaker. One was the real lawyer, one was the guy who had out there and had the client relationships for the Schneider firm. He would have never dreamed of leaving. Neither one of them would have. They were built into that place. It was part of their fabric, and it was who they were as human beings. That is not true of 95% of the revenue-generating partners at the top 100 law firms. And so the concerns about innovation, that making it more of a business, just blink reality entirely. All those places are entirely profit-driven. The law firm partners are making their decisions overwhelmingly based on 70% what's going to be best for their own revenue, and 30% I might go to another law firm to be part of a bigger and better, not even bigger, a better team that could provide better client service. But what we have to do, I think, is focus on the core set of values about serving our clients and not let that get in the way of innovation and change. I will tell you that if businesses owned law firms, they would be very different places, and not in a way I think that was provide worse service to clients, because law firms have to deliver great service for their reputations or they won't have any clients. Particularly given clients' willingness and ability to change law firms. That is no longer, the loyalty of the clients is not what it was in the days of Bernie and Buddy and the Schneider firm. And what they would do is insist on accountability, responsibility, performance in a way that I think would make the practice of law better, but I just don't see it happening. We've got our hands on the wheel as lawyers, and we are not letting anybody else into the club.
On that note, allow me to digress from entrepreneurship. I am not.
Could you just move that microphone a little closer to you? Awesome. Thank you.
I am not an attorney, but I am an advocate for better access. And what drew me here today was you. I wanted to meet you. I am currently a student at the university, going to graduate with my degree in May, not from the law school. But I, for one, am very glad that people like you exist, the so-called ambulance chasers. I had the privilege of working with you by telephone. I did not know who you were, and it's probably a good thing. But
many people say that.
I call myself an accidental advocate. I was a litigant in the Third Circuit here in Collins Grove v. Palmyra Board of Ed that gave rise to the Winkleman case 10 years later.
Sure.
And for us, people like us who have these cases that maybe don't rise to the level of profitability that some of these other big cases do, there are many, many people out there who need more advocates like you to be able to zero in on their cases and champion that. And fortunately, for the work that you did and Jean-Claude, parents now have reestablished a right to represent the rights of their children. So I thank you. It's a pleasure.
That's super kind of you. I mean, it's really been, for me and for every lawyer who does pro bono work, right? I'll be perfectly honest. The reason you should want to do pro bono work is because it's the right thing to do. Pick whatever side. Pick liberal, conservative causes, represent the state, represent the criminal defendants. I don't care. Pick what you believe in. Do it because it's the right thing to do. It is us giving back. It is not why I do pro bono work. It should be, but it isn't. I'm just being completely honest with you. I do pro bono work because of the opportunities that it has given me. I'll just be honest, right? There are people who are driven to get to the right result by the right reason. I was driven to this result for a different reason, but I do half my work pro bono because it has given me unbelievable opportunities to work with the law students that got my entire practice started. And what has really changed in the Supreme Court bar is that there's a huge proportion of work that's done pro bono now. In fact, there are almost no profitable Supreme Court practices because of this. Because there is so much, we went from having 5 lawyers who did this to having 30 law firms and 5 or 6 clinics that now do this work. The competitive pressure is such that a massive proportion of Supreme Court work is now done for nothing. Everybody wins except the law firm partners, which I'm fine with. But the thing that we have to do is we have to find every opportunity for that, because most cases aren't Supreme Court cases. The great majority of important developments in law happen in other places. They happen in homeless shelters, they happen in battered women's facilities, they happen in immigration facilities. That's where people's lives are really, there's the occasional healthcare case, it's going to be a big deal. But when you talk about the impact of the law, and one thing that law schools are doing through clinical programs, that big firms are doing through their pro bono programs, is they're realizing you can get people unbelievable opportunities. We got to have the right set of values, we need to have the right oversight and experience so that people know what they're doing. But the happy coincidence between the great opportunity for a young law student or a young lawyer to have an actual client who is their responsibility, they will kill themselves to do a good job because they're so invested in that opportunity. And so while it's true that there's a lot more pro bono work going on at the Supreme Court now, which is all to the good, I hope to see that the continued growth of it in kind of free legal services, because the world is, to our great detriment, is run on the law. And the law puts people in a bad spot a lot of the times, unjustifiably. And there's a lot of alignment between really fancy lawyers making a whole bunch of money for people who have, and the government and institutions that have those resources, and people who don't.
I'm just curious what you think, how you think the Fisher versus Texas affirmative action case will come out.
Sure. So when Sandra Day O'Connor was on the Supreme Court held in the Grutter and Gratz cases that you could have race as a factor in the admissions of higher education in state schools. The 14th Amendment says that there'll be equal protection of the laws. That applies to governmental educational institutions, not a private school like Princeton, which might be subject to different statutes, but a school that belongs to the people through the government is subject to the Equal Protection Clause. The Supreme Court said you can have race as a factor in admissions sometime, and we're not really going to tell you more than that. But it was still possible. They had struck down the undergraduate college admission program in the Gratz case, and in the Grutter case, they had upheld it, kind of a split the baby thing. And then Sandra Day O'Connor retired, and she was replaced by Sam Alito, a brilliant guy. I want to say to all the justices, you're awesome. Very smart, wise, but materially more conservative justice. And the Supreme Court has gone through a variety of pieces of what you might call Sandra Day O'Connor's legacy, which I think she probably regards as her legacy, and undone them. And it has done that started to do that in abortion, it has done it in campaign finance, it has done it to some extent in race, in a case called Parents Involved, which was about school busing, and is about to do it in affirmative action. Because what you have to look at is when Sandra Day O'Connor was on the Supreme Court, go find all the things that Justice Kennedy really believed in and was in dissent. And this is one of them. Justice Kennedy is extremely suspicious of the use of race in governmental decision-making. And so, as with abortion, as with campaign finance, the Supreme Court's going to come along in the Fisher case, and assuming that for technical reasons the case isn't moot because of Fisher's graduation from college, it is going to say either the Grutter case is overruled, or the Grutter case is different because that person's name was Grutter, this person's name is Fisher. That was a case from Michigan, this is a case from Texas. And they have a way of kind of interring old Supreme Court precedent when they don't want to outright overrule it. But it's done. Put a fork in it. This court has taken a step to the right, really is very concerned that, look, if we make decisions based on race, we are engaging in race discrimination. And that is not to say that they will say that we have to have color blindness. There are justices in the Supreme Court who think that. Justice Kennedy does not believe that. But he believes that you are going to have a very concrete history of discrimination that you are resolving and remediating through the use of race in decision making. Now, what practical effect will have it? Well, I think a lot of admissions committee will say, all right, race is not a factor in decision making. I still would like to have a very diverse class. And so let's not talk about the race of the applicants, but there is going to be that concern for people who do disfavor affirmative action. But in the Fisher case, the case is either moot or Fisher wins and Texas loses. It's really kind of a weird spot. The person who is defending this program is Rick Perry, right? This is the University of Texas's own program. It's Texas's affirmative action program, and it's a very weird situation where you have a very conservative administration from a very conservative state pressing affirmative action. They may not do it with complete victory. Yes?
Please address the healthcare law.
Okay. Hello, healthcare law. So the healthcare law has a bunch of different moving pieces. Let's talk about the individual mandate. That's what most people care about. This is the requirement that in a few years, with certain exceptions, everybody needs to have health insurance. There are 50 million uninsured Americans at the very least, and this law is an attempt, the heart of the Affordable Care Act is an attempt to resolve that problem. It is alleged to be outside Congress's powers under the Commerce Clause. Article 1, Section 8 of the Constitution says that Congress gets to regulate interstate commerce. There's also a provision in Article 1 that says Congress can do what is necessary and proper in furtherance of its other powers. So the question is, and let me put it to you, I'll give you both the challengers' view of it, and then I'll tell you the right answer. The challengers say this statute, that the Constitution says to Congress, you can regulate interstate commerce. So if you're going to regulate interstate commerce, we're going to have some commerce to regulate. It doesn't say you can create the commerce and then regulate it. So the argument here is that if you don't have health insurance right now, I can't regulate it because there's nothing to regulate. If instead I allow Congress to say, you must have health insurance and then I'm going to regulate it, what limits are there on Congress's commerce power? Like what restrictions, why can't Congress then regulate everything? Because the Supreme Court has said basically everything is interstate commerce. In the Rage case, for example, in 2006, there was a woman, Ms. Rage. She came to the Supreme Court, she said, look, I live in California. I have taken my house, I'm going to wrap it in saran wrap. Okay, there's not going to be an oxygen molecule that comes from another state. I'm going to grow one sprig of marijuana. That marijuana came from a marijuana plant in California, which came from a marijuana plant in California. I'm going to take water. I promise you that this water did not come from another state. I fused the oxygen and the hydrogen together in my house so that everything about this happened in California. I'm going to grow this marijuana, I'm going to smoke it, I'm going to get high, it's true, but I'm not going to leave the house, I'm certainly not going to visit another state. Nothing will happen outside California. The Supreme Court said, well, obviously that affects interstate commerce. Because everybody on the Supreme Court, conservative or liberal, finds something to like in expansive federal power. Liberals on the Supreme Court, like the federal civil rights laws, they do not want to have a rule that says if you are in Tennessee or South Carolina, my home state, and you don't want to serve African Americans, or why make it about the South, or New York State, and you don't want to serve it for African Americans, you say, yeah, this is an African American from my state, and I'm a white person from this state, this is interstate commerce, so the federal civil rights laws can't force me to do it. No, the Supreme Court says the food's going to come from another place, you're going to have visitors from another place, everything is all interstate commerce. So liberals like a broad reading of the commerce power, conservatives like a broad reading of the commerce power. And that's really the dilemma the challengers get to at the Supreme Court. The Affordable Care Act affects hundreds of billions of dollars in interstate commerce. The case is basically, in my view, a individual liberties case framed as a commerce case in drag. Right? What the challengers are really saying is, I mean, is the federal government ever going to stop? I mean, is there not, can't we have some principled limits here? The framers of the Constitution, let's be perfectly clear, would have never imagined the federal government we have today. That the Interstate Commerce Clause of Article 1 of the Constitution would produce the level of federal regulation that we have now, and the power of the federal government versus the states would be utterly unimaginable. But that ship has sailed for the Supreme Court because of the civil rights laws, because of the drug laws that conservatives like, and these challengers are trying to say, can't we finally put some limitations on this? And the limitation that they would like to create and have enacted or adopted by the Supreme Court is at least only let commerce regulate commerce that actually exists. The difficulty, apart from the Supreme Court's prior precedents, is that the argument that you aren't purchasing health insurance, therefore you're not engaging in commerce, is actually phony. The reason is that you, if you aren't purchasing health insurance, are deciding to self-insure. And what you're deciding to do is if you ever were to get sick, you will pay for it yourself. And that decision, whether you pay for it yourself or don't, has massive effects throughout the economy. And if you didn't pay for it, then your costs would be passed on to lots and lots of other people. And so what Congress is regulating in the statute is your decision to self-insure rather than insure with a third party. And your decision to self-insure rather than insure with a third party unquestionably affects interstate commerce. This is really a case about, that's the amazing thing about the Supreme Court. The country has been around for hundreds of years, and we are debating the foundational things about the nature of our government. It's one of the wonderful things about the place where I practice. But this Supreme Court has basically said Congress can do most of what it wants. And it would be very surprising very surprising if this Supreme Court were to say, I'm sorry, I know this affects hundreds of billions of dollars in commerce, but it doesn't affect interstate commerce enough to be within Congress's power. So the law will be upheld.
Two more questions. Yeah.
Sure. I was just wondering, as someone recognized for fostering public awareness of the court, if you'd share your thoughts on televising oral arguments there, I guess particularly considering your comments on inertia.
Right. Well, it's a fantastic illustration of that point, right? So the Supreme Court thought it was mind-blowingly advanced when in like 2009 it developed a website. Now, you still can't do electronic filing. You can't access any of the documents at the Supreme Court, the briefs that are filed there through the website. The Supreme Court thinks it is, it mulled for months the question of whether to release the audio on the same day of the healthcare arguments. Now, they are changing, but they are changing at the Supreme Court's pace, which is glacial. Now, that's not to say it's a good thing or a bad thing. There is a lot to be said for institutions that kind of really think things through and move slowly. But the Supreme Court is really the epitome of that, and that is it moves at literally a glacial pace. So there's the question, will the Supreme Court allow television cameras in? And the answer to that question is someday, in kind of an epochal sense. And that is, there will come a day, and it may well be 50 or 100 years from now. That's kind of their take on it. There is maybe a vote among the 9 justices in favor of televising the hearings. Not much more than that. Now, then there's the normative question. Is that a good thing or a bad thing? I think it's a terrible thing. This is another thing. Like, the people who do what I do don't say in front of groups or on camera, the Supreme Court is doing something horrible. And that they may be more successful Supreme Court litigators for it. I don't mean to insult anyone. It's a very considered decision. But my view about this is that it is America's court. There are hundreds of millions of Americans. It is incredibly expensive to get to Washington, D.C. Only 10,000 people get in and see a Supreme Court argument in any year. It's very, very, very hard to experience it. And I believe, as Americans, since it's the Supreme Court, the only one that's called for by the Constitution, people have a right to see it. I think that you have a right to understand what the questions are like and to really experience it in that way. And we are a visual culture. People watch the television news a lot more than they read the newspaper. Americans just experience things in that way, being there, being present, or watching a video of it. It is shockingly boring. Okay? It is not exciting. It is not something that will cause a lot of attention. There are a lot of courts that have video of their arguments. Nobody watches. I don't think people would watch the Supreme Court. The dilemma is that, and the problem is, and the fault of this all lies with Jon Stewart. And so what the Supreme Court really fears is that on The Daily Show, someone's going to take a clip of Justice Scalia saying something relatively over the top, like, "Are you kidding me?" And that will be America's image. And I'm sorry, the presidency has survived always being on camera. Congress has survived always being on camera. And I do believe, actually, that our respect for these institutions would grow, not be diminished. And the uniform view, I think, essentially, of judges and justices who sit on courts that have video is that it has been not a negative. But the justices like their anonymity. They take their jobs incredibly seriously, and they think it would diminish the level of respect for the institution. I just think they're wrong.
I'm also fascinated by the Supreme Court, and as an undergrad, I studied it a lot in terms of political science. And I read and heard a lot of opinions that oral argument in the Supreme Court doesn't really matter. It doesn't really change anything, and to a lesser degree, maybe even the written briefs. So could you kind of comment on your thoughts of that?
So I have to answer this in 2 ways. One is I have a professional responsibility to say that if you ever have a Supreme Court and you need an advocate, it is extremely important that you take out your checkbook and you hire a highly experienced Supreme Court advocate. Okay? You are doomed to failure if not. And you only know one really personally. I feel we've made a connection. So that's one answer. That's kind of the advertising answer. Then there is the answer that I do believe the briefing is extremely important. I have actually come to believe that it's harder for me to be a lawyer now than it was 10 years ago, because I understand kind of more and more levels to it, and you have to work harder and harder and harder at it. It hasn't gotten any easier, it's gotten more difficult. I do believe the briefing is extremely influential. That's why the Solicitor General's office wins 2/3 to 3/4 of its cases. They are just very good lawyers. They pick their shots, they get the right cases up at the Supreme Court, but they're just better. They're extremely good. Oral argument, I think, makes a difference. You know, 1 out of every few cases, a justice is going to change his or her mind on the outcome. The reason it's so few is they aren't deciding any cases. They've got 78 cases. They've got 4 law clerks, many of them from Penn, very talented people, and they write all these memos. They work incredibly hard before the oral argument, right? Unlike in a state trial court, or a court of appeals, where the first real experience of the case for the judge is the oral argument. The justices know a lot about it. This is actually why Clarence Thomas is so misunderstood. It's really regrettable that he kind of leans back in his chair and closes his eyes, but his chambers works unbelievably hard on the cases ahead of time. He's actually thought a ton about it before he gets to oral argument, is just listening to see if anything changes his mind. So if it only happens 1 in every few cases that one justice changes his or her mind, then you have to have a 5-4 case, and it has to be someone going from the 5 side flipping over to the 4, rather than somebody already on the winning side, expanding the winning majority. But I do think that oral argument can make a big difference in how the case is decided. Very frequently, the justices will show up at oral argument and think, I think the petitioner is going to win, or I think the respondent's going to win. But they won't have thought 3 levels through what the opinion is going to look like. And so when I started out as a Supreme Court advocate, I stood up in that Cunningham case that I mentioned, and I tried to convince all 9 justices that I was right. I lost 9-0. It was terrible. But what I try and do now as a Supreme Court oral advocate is go to the argument and try and do as little as possible. And that is, I find 1 or 2 justices who I think could be moved on 1 or 2 questions. This is the art of the possible. I now try and accomplish less and less and less, but work much harder at it. And so you're quite right. I don't go in there and try and change everybody's mind. I try and listen. Most of what happens at the Supreme Court, and this will be the last thing I say, is the justices, because they know so much about the cases, are very rarely asking honest questions. It's not because they're not honest, it's because they're not questions. What they're doing is the Supreme Court doesn't meet ahead of time in an oral argument. They meet after the oral arguments. So the first chance and only real chance that they have to persuade each other is at the oral argument. So the justice comes in, thinks they're right, and so they are asking me a question in order to talk to that justice, right? And so the questions are actually statements. And so when the other person is talking to the Supreme Court oral argument, I don't listen to the answers at all. I listen to the questions and look for someone who actually has some uncertainty about some issue in the case, and then I talk only to that person, only about that question. And I try and do it when I'm the advocate as well. And so it's a very odd form of advocacy because they are so highly prepared and so, they've been thinking a lot about these questions for 10 or 15 years. Okay, thank you so much.